A loan is actually a deposit of money by the customer with banker. A loan is deposit of money by a customer with banker. Gimbel Bros versus White, 10 New York State 2D 666 667 256, Appellate Division 439, Black's Law Dictionary 4th edition, page 1085. Did you really get a loan? Did you really get a loan when you contracted to borrow money from the bank to pay for your home? Or was it just an exchange, your note for cash, but the bank called it a loan? Or did two loans occur? The banker says, repay the loan because the bank lent you money. We simply ask one question: should the one who funded the loan be repaid the money? Whether they answer yes or no, the bank must forgive the loan and zero out the debt. That is the one question that they do not want to answer because the borrower funded the loan as proven by the bank's own bookkeeping entries. Before an attorney can sue for foreclosure, he must show that the defending party, you, breached the agreement. The attorney needs a witness to give testimony that there is an agreement and that the agreement has been breached. If Rich, as an example, testifies in court that there was a loan when he knew that there was only an exchange of equal value, Rich would be giving false testimony and would be called a false witness, grounds for impeachment. In a normal court foreclosure, the lender does not come to the court to give testimony. The bank attorney uses the alleged promissory note with the alleged borrower's signature as the witness in court to claim that there is an agreement. That document, by the way, is a forgery. That there was a loan, that the lender fulfilled his agreement, and that the alleged borrower did not fulfill the agreement to repay the money. Instead of the attorney using Rich to give oral testimony, the attorney used the promissory note or the forgery that was presented before the court as the witness, as the evidence to sue the alleged borrower. So we're going to impeach what they call a copy, but we know to be a forgery. We're going to impeach that evidence, all right? There is a legal concept of form versus substance. The form is the promissory note, which says that the lender lent money to the alleged borrower. The substance is the money trail, the bookkeeping entries. The substance shows that there were two loans exchanged, equal value for equal value. The borrower was required to repay his loan to the bank plus interest, but the bank never repaid the debt it owes to you. IOU was exchanged for IOU. The two newly created IOUs cancel each other out. Acts in reference to this issue of whether greenbacks could be used to pay state taxes. In Perry versus Washburn, 20 California 318 1862, the California Supreme Court ruled that United States notes could not be used to pay state taxes, especially where a California statute required taxes to be paid in coin. In State Treasurer versus Collectors Sangamon County, 28 Illinois 509 512 62. The Colorado Constitution, page 12, states only coin can be used to pay debts. Subsection 10, powers denied individual states. 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold or silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any titles of nobility. In reference to the lawlessness of the greenback currency of the Union, this issue involved not one single case, but a multiple of cases spanning some 15 years. Before delivering any opinion wherein a challenge to the constitutionality of the Legal Tender Act was concerned, the U.S. Supreme Court rendered certain opinions in cases related to this issue. In Bronson versus Rhodes, 74 U.S. 7 Wall 229, 1869, the court held that a bond requiring payment in specie coin could not be discharged by paying greenbacks. In the case immediately following Bronson Supra, the court in Butler versus Howards, 74 U.S. 7 Wall 258, 1869, held the same way in reference to a contract requiring payment in specie. In New York versus Supervisor, County of New York, 74 U.S. 7 Wall 26, 1869, the court held that legal tender treasury notes were exempt from state taxation. By 1870, some 8 years after the adoption of the first Legal Tender Act in 1862, the court was finally required to pass upon the constitutionality of those acts. As noted above, the Kentucky Supreme Court had held these acts to be unconstitutional in Griswold versus Hooper, Supra, and it was to this case that the Supreme Court granted certoria. And I know I'm pronouncing that wrong. It's Certiorari, certoria. The chief archivist of the Legal Tender Acts had been Treasury Secretary Chase, who by now was sitting on the court as its Chief Justice. And it was Chase who wrote the majority opinion in Hooper versus Griswold, 75 U.S. 603, 625, 1870. The issue in this case involved whether legal tender notes could be used to discharge a debt contracted before the passage of the first Legal Tender Act, and this determination necessarily involved the constitutionality of those congressional acts. Chase noted in the opinion that the legislation adopted by the Congress making Treasury notes a legal tender occurred at the height of the troubling times and that the motive for the acts was patriotic in nature. This was obviously stated because of his own personal involvement in obtaining passage of the acts. Nonetheless, and notwithstanding personal motives and convictions, which certainly played a part in passage of this legislation, it was time to test the conformity of the acts with the U.S. Constitution. Chase analyzed the specific provisions of the Constitution which granted Congress various power and determined there was no express grant to declare Treasury notes a legal tender. There being no such express grant, he then examined specific congressional powers to determine if any implied power would sustain the acts. He examined the power to coin money, to borrow, to regulate commerce, and to declare war, but there he found no method for developing an implied power, which would uphold the acts. He examined the spirit of the Constitution as well as certain prohibitions contained therein, none of which could be useful in supporting an implied power. Finding no support for the constitutionality of the challenged acts, he found them unconstitutional. Quote, "We are obliged to conclude that an act making mere promise to pay dollars a legal tender in payment of debts previously contracted is not a means of appropriate, plainly adapted, really calculated to carry into effect any express power vested in Congress, that such an act is inconsistent with the spirit of the Constitution, and that it is prohibited by the Constitution." The above quote would also apply to the use on paper money being in direct opposition to the Constitution of the states and the United States to pay a debt in anything other than coin. Hager versus Reclamation District number 108, 111 U.S. 701, 706, 1884, decided only 2 months after Juilliard. In Hager, one issue involved the type of currency to be used to discharge a liability for state taxes. In holding that such taxes had to be paid in specie coin pursuant to state law, Justice Field relied upon Lane County and stated, The extent to which the power of taxation of the state should be exercised, the subjects upon which it should be exercised, and the mode in which it should be exercised were all equally within the discretion of its legislator, except as restrained by its own constitution and that of the United States. At present, there are no federal taxes that are appropriated among the states as is required of direct taxes. An additional point of consideration arising from the fact that neither Knox nor Juilliard sanctioned an irredeemable currency. The court in Knox expressly held that representatives of federal liability, treasury notes, were to be taken as equal of coin, with the understanding that these notes would eventually be paid. Redemption began in 1879, and at the time of the Juilliard decision, such notes were convertible into specie coin. The court has never sanctioned the complete suspension of specie payment, as well as was plainly demonstrated in Ward versus Smith, 74 U.S. 447, 1869. Notes, not thus current at their par value, not redeemable on presentation, are not a good tender to principal or agent, whether they are objected to at the time or not. 74 U.S. at 451-52. Therefore, a federal currency which is not redeemable in specie coin is repugnant to the Constitution. To thoroughly get the term excise straight, let's let some lower federal courts clarify the term excise for us also. American Airways versus Wallace, 57F period 2D 877-880, the terms excise tax and privilege tax are synonymous. The two are often used interchangeably. Manufacturers Trust versus US 32F, Superior Court 289, a tax levied upon property because of its ownership is a direct tax, whereas one levied upon property because of its use is an excise tax, duty, or impost. From the Legal Encyclopedia, American Jurisprudence, Chapter 71, State and Local Taxation, Section 28, we read, the obligation to pay an excise is based upon the voluntary action of the person taxed in performing the act, enjoying the privilege, or engaging in the occupation which is the subject of the excise, and the element of absolute and unavoidable demand is lacking. You can avoid an excise tax by avoiding or not participating in the activity or privilege that is the subject of the tax. Since the income tax has been ruled to be an excise tax, then the same principle would apply. If you do not engage in the privileged, licensed, taxable activity or occupation, then you will not be subject to the tax. It is voluntary. Voluntary, I say again. And again, from American Jurisprudence, Amjuris, Chapter 71, Section 94, we read, the inalienable right to acquire, possess, or own property cannot, according to one doctrine, be made the subject of an excise tax. The theory appears to be that a tax upon the right to acquire, possess, hold, or own property is tantamount to a tax upon the property itself, and hence must be regarded as a property tax and not an excise tax. 71 Am Jurisprudence 194 says a tax on an essential attribute of a thing is a tax on the thing itself, and no tax can be imposed on the right of ownership, which is not also a tax on property. An individual, unlike a corporation, cannot be taxed for the mere privilege of existing, nor for the enjoyment of the right to own property. By June 1st, 1933, Congressional Joint Resolution number 192 was proposed to make it against public policy to pay any obligation in gold. That's the abrogation of the gold clause, by the way. It was during the debate on this resolution that the fact was made known that the Federal Reserve banks possessed virtually all the federal gold clause bonds to mature within the next 6 months. 12. This resolution was enacted on June 5th, 1933, and notwithstanding the fact that it was only a joint resolution, it was accorded the force of law, because it's also found in 48 statute at large, 112. Okay, and statutes at large are legal evidence of the law from the highest to the lowest court. Okay, it was accorded the force of law. It also manifested a trust into existence when they did the abrogation of the gold clause. They took our gold under Vietas arms and put the National Guard on the freeways, highways, byways, and passages of the people to rob the banks, all right, of all our gold, which was a Fourth Amendment violation, where they didn't have a warrant to seize our property and assets, okay? And it also violated the Constitution because they were supposed to compensate us for the property that they took in their need of necessity. Now it is illegal to pay for anything in gold, so where does that leave us when it comes to paying for something like taxes that are only payable in gold coins, as declared in the state and federal constitutions? If one wishes to pay a voluntary property tax on one's private property, the Legal Tender Acts do not attempt to make paper a standard of value. We do not rest their validity upon the assertion that their omission is coinage or any regulation of the value of money, nor do we assert that may make anything which has no value money. What we do assert is that Congress has power to enact that that the government's promise to pay money shall be for the time being equivalent in value to the representative of value determined by the Coinage Acts, or to multiplies thereof. It is hardly correct to speak of a standard of value. It is then a mistake to regard the Legal Tender Acts as either fixing a standard of value or regulating money values, or money which has no intrinsic value. 79 U.S. 553. Dissenting from the decision in Knox were Chief Justice Chase and Justice Clifford and Field, who rose to the occasion and set forth innumerable facts, and arguments against the acts. The decision in Knox resolved the issue of the constitutionality of federal bills of credit during war, but it was still an open question as to their use in time of peace. In 1875, Congress enacted a Species Resumption Act, which became effective in 1879. In 1878, Congress passed additional legislation permitting the reissuance of Treasury notes after redemption. By 1884, the Supreme Court was confronted with the issue of whether legal Treasury notes could be reissued in peacetime. In Juilliard versus Greenman, 110 U.S. 421, 448, 1884, the Supreme Court expanded the Knox Doctrine to allow peacetime issuance of legal tender Treasury notes. Congress is authorized to establish a national currency either in coin or in paper, and to make that currency lawful money for all purposes as regarded the national government or private individuals. In writing this opinion, Justice Gray successfully located the origin of this in the express grant to Congress to borrow money. This was apparent notwithstanding the fact that the microscopic examination of the Constitution by Justice Strong in Knox failed to reveal the source of this hidden power. As justification for this holding, Justice Gray relied upon the sovereign powers of European government, the law of the mother country. something which was totally new to construction of the American Constitution. Wasn't really new. We adopted the laws of the mother country when we came over here. That's just how it is. The dissents in both Knox and Juilliard were exceptionally well written and documented rebuttals of the erroneous findings of historical facts relied upon by the majority in both cases. Justice Field aptly stated the case of the dissenters by noting that no jurist or statesman in our country prior to the Civil War ever mentioned or alluded to the power so readily found by the majority in both Knox and Juilliard, all conceded as an axiom of constitutional law that the power did not exist. 110 U.S. at 454, the defects in finding of historical facts, argument, and reasoning in both cases were ably pointed out by George Bancroft in his work, A Plea for the Constitution, written in direct response to the Juilliard decision. And if Bancroft did not fully destroy the fallacies of Juilliard, Dr. Edwin Viria, in his book Pieces of Eight, has conclusively done so. It is not the capable works as above described which have limited the scope of the legal tender cases. Instead, it is the decisions of the same court which render both Knox and Juilliard that define the limits of the legal tender powers of Congress a full 2 years before the Supreme Court decided Hepburn, and 3 years before Knox. The Supreme Court determined a limitation on federal bills of credit in the case of Lane County versus Oregon, 74 U.S. 7 Wall, 7177, 1868. The rationale found in both Perry versus Washburn Supra and in State Treasurer versus Collector Supra was followed in Lane County, and the court there held that the state law requiring taxes to be paid in specie coin could not be circumvented by payment in greenbacks, reasoning there is nothing in the Constitution which contemplates or authorizes any direct abridgment of this power by national legislation. Lane County was rendered by the same court which rendered Hepburn, and the majority of which decided Knox. And a similar case was rendered after Juilliard, that case being Hager versus Reclamation District Number 108, 111 U.S. 701 706 1884, decided only 2 months after Juilliard. In Hager, one issue involved the type of currency to be used to discharge a liability for state taxes, and holding that such taxes had to be paid in specie coin pursuant to state law, Justice Field relied upon Lane County and stated, the extent to which the power of taxation of the state should be exercised, the subjects upon which it should be exercised, and the mode in which it should be exercised were all equally within the discretion of its legislator, except as restrained by its own Constitution and that of the United States. It appears that the conveyance of congressional Juilliard powers to these banks was an outright gift to a very powerful, self-interested financial group, subject to no control or restraint by Congress. The Federal Reserve System was given unbridled power to expand or contract the number and amount of outstanding federal bills of credit. This legislation is unconstitutional for this reason. On August 28, 1933, Roosevelt issued an executive order which required information returns for gold ownership and prohibited possession of gold except by license. Roosevelt, in his war upon gold ownership by American citizens, was the Gold Reserve Act of January 30th, 1934. 48 Stat 337, failure to file the required returns and possession of gold without license were made criminal offenses. This above quote means that the gold wedding bands worn on the right hand of most American people is illegal to own. What an interesting law that is. We, the people, want to know why Congress has forced us to borrow our own money into circulation at interest without or with the United States bonded indebtedness. We believe, as did President Lincoln, that if a nation can issue a $5 bond, it can issue a $5 bill. We, the people, gave no authority to the Federal Reserve Bank to coin or create the nation's money. We delegated that power to Congress. Even if Congress should feel incompetent to manage the nation's money supply, it has no power to delegate nor to relinquish that authority. Barter is the system of exchange whereby property is directly exchanged for other and different property. No one can be damaged by barter. Specie coin is an improvement of barter exchange. Here, exchange occurs via a common form of property, gold or silver, and property and wealth are exchanged for property and wealth. Trade and commerce achieved through the use of specie coin is similar to barter, and nobody gets damaged thereby. However, to prostitute the specie coin exchange by replacing it with something of worthless value results in wealth and property being exchanged for nothing of value. This is nothing more nor less than theft. Our nation is nothing more than a society of thieves, and we steal each other's wealth, property, and labor with something that is inherently worthless. However, while citizens of this nation unknowingly steal from one another, the creators of these monetary instruments are the greatest of thieves. The Federal Reserve banks and all the private commercial banks of this nation are the creators of the Federal Reserve notes and bank demand deposits. These institutions obtain whatever real resources, wealth, and labor they need or desire merely by printing on paper and issuing credit. These institutions truly acquire everything they need or desire, such as bank buildings, employee labor, farmlands, or factories, for nothing but the cost of printing. Another serious defect of our currency system consists of the fact that the supply of this purported currency can be manipulated at will by the Federal Reserve System. By purchasing government bonds, the Federal Reserve Open Market Committee can expand the credit supply. By selling bonds, it can contract that supply. By the Federal Reserve Board decreasing bank reserve requirements, private banks can increase deposits. The inverse works for an increase in the reserve requirement ratio. The American people have absolutely no control over the volume of currency and credit in circulation. When the currency supply is deliberately and intentionally decreased by this manipulation, innocent victims are created who cannot repay loans. This results in loss of property through foreclosures. Banks simply extend credit when loans are made. The currency for which these and all other loans in America can be redeemed is known as the Federal Reserve Note, FRN. The reserves held by the Federal Reserve banks have been adamant by the government in its work titled A Primer on Money to be Backed by Nothing. Banks are prohibited by law from loaning their credit. See Citizens National Bank of Cameron versus Good Roads Gravel Co. 236 S period W period 153 161 Texas Appellate Court 1922 National Bank of Commerce of Kansas City versus Atkins 55 F 465 471 D Kansas 1893 Bowen versus Needles National Bank 994 F period 925 927 Ninth Circuit Court 1899 Merchants Bank of Valdosta versus Baird 160F 642 645 8th Circuit Court 1908 First National Bank of Tallapoosa versus Monroe 69 S period E period 1123 1124 Georgia, 1911. American Express Co. versus Citizen State Bank, 194. N period, W period, 427, 429. Wisconsin, 1923. Howard and Foster Co. versus Citizens National Bank of Union, 130. S period, E period, 758, 759. S period, C period, 1925. Farmers and Miners Bank versus Bluefield National Bank, 11. F period, 2D, 83, 85. Fourth Circuit Court, 1926. Best versus State Bank of Bruce of Abingdon, 144. S period, E period, 501, 503. Virginia Appellate Court, 1928. Federal Intermediate Credit Bank versus L. Harrison, 33. F period, 2D, 841. 8th Circuit Court, 1929. First National Bank of Amarillo versus Slayton in IND School District, 58. S period, W period, 2D, 870, 875 in Texas Appellate Court, 1933. And Ferguson versus 5 Points National Bank of Miami, 187. SO period, 2D, 45, 47. Florida Appellate Court, 1966. Thomas Jefferson once said, if the American people ever allow private banks to control the issue of their money, first by inflation and then by deflation, the banks and corporations that will grow up around them will deprive the people of their property until their children will wake up homeless on the continent their fathers conquered. We, the people, want to know why Congress has forced us to borrow our own money into circulation at interest with United States bonded indebtedness. We believe, as did President Lincoln, that if a nation can issue a $5 bond, it can issue a $5 bill. We, the people, gave no authority to the Federal Reserve Bank to coin or create the nation's money. We delegated that power to Congress. Even if Congress should feel incompetent to manage the nation's money supply, it has no power to delegate nor to relinquish that authority. The Supreme Court has held some of the powers of Congress to be delegatable, but no power strictly legislative in nature. Panama Reef Co. versus Ryan, 293 U.S. 388, 79 L period ED 446. Even where the power was held to be delegatable, Congress was required to lay a policy and to set up a standard. Event versus U.S. 266 U.S. 127, Central Securities Corp. versus U.S. 287 U.S. 12 U.S. versus Chemical Foundation Incorporated, 271 U.S. 1. In the statutes creating the Federal Reserve System and in its subsequent amendments, there appear no stated limitations on the powers and authority of this corporation. The Federal Reserve Act is without authority. Congress has made an unlawful delegation of power strictly legislative. Delegation by Congress of its essential legislative function is precluded by the provisions of the federal Constitution, Article 1, Section 1, that all legislative power granted to the federal government shall be vested in Congress, and of Article 1, Section 8, Clause 13, empowering Congress to make all laws which shall be necessary and proper for carrying into execution its general power. Panama Reef Cove Supra at 388, Union Bridge Co. versus U.S. Supra. Wayman versus Sutherland, 10 Wheat U.S. 1 6 L period ED period 253. Schechter Poultry Corp. versus U.S. 295 U.S. 495 79 L period ED period 1570, and Knickerbocker Incorporated Co. versus Stewart 253 U.S. 149 64 L period ED period 834. It must be understood that the Federal Reserve note is not United States money as defined by our Constitution, although it might be implied by the Legal Tender Act, at Title 31 U.S. 392. Could a piece of paper then represent a foot? This is a relatively simple question. Of course, a piece of paper could represent a foot by being 12 inches long. The same holds true with all units of measure. The pound is merely represented by 16 ounces, but 16 ounces merely represents that pound, just as a piece of paper might represent a pound by weighing 16 ounces. What is a dollar? A dollar, like a foot and pound, backs a standard of value. Congress has said that the standard unit of value for the dollar is to be gold, 15.521 grains and 9 tenths fine by weight, and that this gold at this weight is to represent the dollar, and further, that the dollar of gold shall be the standard unit of value by which all coins and currency are to be maintained. Title 31 USC 314. As early as the Second Congress, it was established that the proportional value of silver to the gold dollar of 15,520 seconds or 15,521st grains of gold, 9 tenths fine. We know that the Federal Reserve notes does not represent either gold or silver. There were 67 billion of dollars in bills as of June 1973 circulating in the form of these notes, and at that time there was only $10 billion in gold within. Oh, dang it. I push that off to the side. Dang, I got to do this because I don't want to lose this. This was a great video last night. That'll work. We know that the Federal Reserve note does not represent either gold or silver. There were 67 billion of dollars in bills as of June 1973 circulating in the form of these notes, and at that time there was only $10 billion in gold within the continental United States. The Federal Reserve note represents no standard of value and is incapable of representing the dollar. This lack of value is fatal to its character and the intention of Congress. What then are Federal Reserve notes if they are not dollars? Was the purpose and effect of the Federal Reserve Act to authorize a new kind of money? Did the government and the Federal Reserve Bank really and in fact contract by these notes to pay the bearer on demand or at any time? Are these notes really promises to make other promises? Federal Reserve notes are in many respects similar to the United States notes. They are both paper, they are both notes, and they both circulate on the credit of the United States. United States notes are engagements to pay dollar, and the dollars intended were the coined dollars of the United States. Bank of New York versus New York County, 7 Wall, U.S. 26. Their name imports obligations. Every one of them expresses upon its face an engagement of the nation to pay to the bearer a certain sum. The dollar note is an engagement to pay a dollar, and the dollar intended is the coined dollar of the United States. A certain quantity in weight and fairness of gold or silver. No other fineness, of gold and silver. No other dollar had before been recognized by the legislator of the nation's national government as lawful money. Bank of New York, Supra at 30. In Knox versus Lee, the majority opinion was written by Justice Strong. We will notice briefly an argument presented in support of the position that the unit of money value must possess intrinsic value. The argument is delivered from assimilating the constitutional provisions respecting a standard of weights and measures to conferring the power to coin money and regulate its value. It is said there can be no uniform standard of weights without weight, or measures without length, or space, and we are asked how anything can be made a uniform standard of value which has itself no value. This is a question of value. We do not rest their validity upon the assertion of the value of money, nor do we assert that Congress may make anything which has no value money. What we do assert is that Congress has the power to enact that the government's promises to pay money shall be for the time being equivalent in value to the representative of value determined by the Coinage Acts, Knox versus Lee, 12 Wall 552553. In March 1968, the government repudiated its promise to pay money, and according to what Justice Strong implied, if there were no promise, there could be no value. The value was derived from the promise of the government and nothing else. The only money that may lawfully circulate within the United States is gold and silver coin. This is the only money Congress may legally issue, and it is the only money to be honored by the courts. The legal tender notes have been the representative of the values and have circulated by general consent as the equivalent to money, but not as money by any legal standard. Money, says Sir Williams Blackstone, is a universal medium, a common standard by comparison with which the value of all merchandise may be ascertained, or it is a sign which represents the respective values of all commodities. Metals are well calculated for this sign because they are durable and are capable of many subdivisions, and a precious metal is still better calculated for this purpose because it is the most portable. A metal is also the most proper for a common measure because it can easily be reduced to the same standard in all nations, and every particular nation fixes on its own impression that the weight and standards wherein exist the intrinsic value may both be known by inspection only. Commentaries on the Laws of England, 1st Blackstone, section 387. The power to coin money is one of the ordinary prerogatives of sovereignty, and it is almost universally exercised in order to preserve a proper circulation of good coin of a known value in the home markets. In order to secure it from a debasement, it is necessary that it should be exclusively under the control and regulations of the government. 3 Story 16. Banknotes and all paper notes are treated as money only so long as they remain current at par and in lieu of coin, but no paper in a strictly legal sense could be money, as money strictly applied is coined metal. There is a necessary distinction between paper being treated as money and paper actually being money. There is a possibility of the former, but there is no possibility of the latter. Bills of credit and negotiable tax receipts were actually the forerunners of the legal tender United States notes, Treasury notes, and all other legal tender paper. The sole distinction is that banknotes are guaranteed by the bank of issue, whereas the legal tender notes are ultimately guaranteed by the government. The laws necessarily relevant to bank notes must apply with like force to notes guaranteed and ultimately pledged to be redeemed by the government. Even prior to 1844, it was held that an action of debt would not lie upon a note to pay a sum certain in current bank notes. Young versus Scott, 5 Alabama 475. The reasoning which led to the conclusion attained in the above case was that banknotes were not money, although they might profess to be its representative. Carlisle versus Davis, 7 Alaska or Alabama, I think it's Alabama, 42. The term banknotes, as employed, here import in their ordinary acceptance such bank bills only as are redeemable in gold or silver, or such as are equivalent thereto. Fleming versus Nall, 1 Texas 246, Pearson versus Wallace, 7 Arkansas 282. There are numerous cases where a designation of the payment of such instruments in notes of particular banks, associations, or in paper not current as money have been held to destroy their negotiability. Irvin versus Lowry, 14 PET 295. Miller versus Austin, 13 HOW 218 228. Ontario Bank versus Lightbody, 3 WEND 101. In the use of the term currency includes only such banknotes as are current, that is, banknotes which are for circulation by authority of law and are in actual and general circulation at par with coin. As a substitute for coin, interchangeable with coin, banknotes which actually represent dollars and cents and are paid and received for dollar and cents at their legal standard value, whatever is at a discount. That is, whatever represents less than the standard value of coined dollar and cents at par does not properly represent dollars and cents and is not money. Leaguer versus Goodrich, 5 CW 187, and Pearson versus Wallace, 7 Arkansas 293, and Ontario Bank versus Lightbody, Supra Clobber versus Biggerstaff, 47 Wisconsin 561. Federal Reserve notes are so hopelessly depreciated that Congress has given up any attempt at redemption. Twice in 14 months, they have depreciated some 18% in the foreign markets, and Congress here at home has offered standard silver dollars for sale at a ratio of $30 in Federal Reserve notes for $1 in standard lawful money. See General Service Administration Form T588R 12-72 and like offers over the years. Thus, Congress has established that there is a ratio of value somewhere exceeding 30 to 1. That act necessarily raises another question, namely, if all coins and currencies, regardless of when coined or issued, shall be a legal tender pursuant to Title 31 USC 392, what is Congress doing when it sells one legal tender for $30 in Federal Reserve notes and another legal tender, Federal Reserve notes? Is it not depreciating the dollar Federal Reserve note tender and declaring that there is a difference in the measures of value? Congress has declared that it cannot redeem its obligations, and yet they have offered to sell lawful legal tender silver dollars at a premium for its depreciated legal obligation called Federal Reserve notes. Does this act make sense? The term current bank paper has a definition and legal significance. It currently does not mean notes at a 50% discount and such as are and sold as merchandise. Lieber versus Goodrich, Supra. Pearson versus Wallace, Supra. When we come back, we'll be talking about Congress was actually purchasing Federal Reserve note paper for lawful money and doing so at a discounted rate.